Good afternoon. Welcome back again to this International Criminology Conference 2023. We are about to start with our panel, Perspectives on Law Enforcement and Community Relations. Today we have the presence of Dr. Charles McLean. He is Professor and Director, Professional Peace Officer in the Metro State University. And we also have the presence of Dr. Philip Mann, Senior Lecturer in Sociology and Criminal Justice from the Old Dominion University. So first I will give the word to Charles McLean for half an hour, and then we will have another half an hour with Philip Mann. And by the end of the session, we have 10 minutes for your questions and comments. So please feel free to add your questions on the Q&A button here on the Zoom options, okay? So thank you, and Dr. McLean, you have the word.
Thank you. Mercio, can you see my slides?
We can see it, yeah.
Terrific. This is, by my count at least, my fourth invitation to speak at the International Criminology Conference, and I'm thrilled at that opportunity. And I want to thank Daniel and his team for courageously inviting me one more time. I want to focus on the number 25. We look back today at the criminal justice system from 25 years ago with rightful derision. We, what were they thinking? We, beating confessions out of people and interviewing them nonstop for 36, 48 hours until they broke, as they say. And we look back and just shake our heads. What were they thinking? Well, I can promise you that 25 years from now, and I'm speaking about U.S. law enforcement, those who follow us will similarly wonder, what were we thinking? And I call this era the awful but lawful era, because too many of our practices, both police, prosecutors, courts, and so on, in criminal justice are awful. But they're lawful and have repeatedly been deemed lawful by the U.S. Supreme Court and other courts. So I maintain that it's time to change, not just evolve, but maybe revolution is what's called for now, not later. And I'm the director of professional peace officer education. I've been a prosecutor for 20 years. So I'm not, in the ivory tower questioning what others are doing. This is things that I've done, and I guess I'm questioning my own background to that degree. Okay. Now, there's a huge list of things that, in my view, need to be different in the American criminal justice system. Here's just some of them. And I'm only going to discuss the 4 that are highlighted here, but let me just briefly touch on those that aren't highlighted. Moral injury occurs to people when they are obligated to experience things that don't match with their ethical core, their moral core. And moral injury is what happens when you, for example, do something distasteful to you or see others do something that is distasteful to you. And did my slide just go back to the next one? Oops. Let's see if I can get back there. And moral injury has a consequence. And if you look at it through the lens of law enforcement officers, they, just like soldiers, see tough things on the job. And when they see tough things, it leaves a mark. Compound trauma is related, that you experience a new trauma before the last trauma has resolved itself. That ends up literally changing the brain chemistry, and in fact, the brain physical nature, and also similarly leaves a mark. And now we have law enforcement officers in the field who have both moral injury and compound trauma, not all, perhaps even not most, but certainly many. And what that does, it makes them, unfortunately, quicker to shoot, less likely to see options, more likely to overestimate the threat, and so on. And so although we allow behavior by law enforcement to pass muster in the courts, there's something we can do about it. This is awful. We ought not be having people in the field who are, doing 12-hour shifts and working overtime outside of that, and have too much stigma in the workplace to actually address their mental health. Fourth Amendment erosion, well, it started strong, and certainly was intended to be strong protection against unreasonable searches and seizures. In fact, I would argue it was strong against anything other than warranted seizures. Back when the Constitution was ratified, there were no non-warranted searches, or if there were, that evidence was not usable in court. The people at that time felt that police officers were just minor functionaries. They certainly wouldn't be given the discretion to do what properly rested with the true decision makers at the time, the courts. With respect to discrimination, excessive force, so much has been said about that, so much should be said about that. I'll mention a couple of statistics later on, but that's another issue. Cash bail, where it inures to the detriment of poor people, even for the same offense with the same criminal background. And so that ability to be fair and just is sacrificed. And then finally, capital punishment and other really severe sentences which characterize U.S. criminal law. Capital punishment, the U.S. is one of the few developed nations that continues to use capital punishment, and sentencing maximums are so high now that it gives prosecutors tremendous power to basically negotiate any plea they want. I want to ground this in the thought of the social contract. And for those who are unfamiliar with that, it is that agreement between the people and their government that in exchange for the people giving the government centralized powers, the government, as a quid pro quo, says, I will guarantee you these protections. The Constitution could not be ratified, not enough states ratified it, until the Bill of Rights was added. So the Bill of Rights, which includes the First through 10th Amendments, it includes all of the important criminal procedure rights. I'm not sure why that's going forward. It is part and parcel of that agreement between the people and the government, part of that contract between the people and the government. And the contract itself, the Constitution, provides within its own terms, how it can be amended, how it can be changed. And it can only be changed by the people, not by judicial fiat, not by a Supreme Court that goes in a particular direction other than what the Constitution provides. And essentially, this social contract, if you will, between the people and their government, it provides that law enforcement in the United States holds those immense powers, the power to enforce the law, to change people's criminal history and reputation and freedom, and sometimes very life, in trust for all of the public, all of them, equivalently at all times, so that fair justice is delivered, not just promised, not aspirational, but delivered, so that equal justice is delivered. And those guarantees are in that indispensable part of the social contract, the first 10 amendments. Now, there was a time in the United States where we did a better job of honoring the social contract. An example of that is the Warren Court, which is from 1953 to 69, when really most of the key criminal procedure cases were handed down that truly honored the social contract and truly honored the meaning of those first 10 amendments. Mauricio, can you tell me why this is advancing automatically? If not, I'll just keep bouncing it back. So, for example, the opinion rendering involuntary confessions inadmissible, that's from the Warren Court, and extending the exclusionary rule against state actors, that was the Warren Court, and Wong Sun with Fruit of the Poisonous Tree also being excludable. That's from the Warren Court, and so on and so on. You'll recognize some of the names, perhaps: Gideon versus Wainwright, Brady versus Maryland, Messiah versus United States, Escobedo. Miranda versus Arizona. Those were from the Warren Court when social contract meant a great deal. Ever since then, each succeeding Supreme Court leadership and membership has eroded those guarantees. In fact, each one of those guarantees listed under Warren Court has been eroded by each of the subsequent courts. And in fact, many of those original promises that were part of that social contract, not a unilateral contract, a bilateral contract, have been eroded and in some cases almost evaporated by subsequent opinions of these later courts. So that's the social contract, which exists, and we need to honor it. It's not aspirational, it's a requirement. It's part of that contract, and one side can't just change that contract. It has to be by agreement. Here's one example of the moral injury and compound trauma thing I was talking about before. This is the use of force continuum, or one version of it. And the way it's interpreted is, if you look at the left side, that's the observed actions by the subject as being encountered by the law enforcement officer. And at the bottom, when that person is being compliant, pardon me again, at the bottom, when that person's being compliant, then you look straight across at the other side, the officer then is free to respond with verbal commands. If instead the officer perceives that the subject on the left side now is being resistant, then you look to the right side, the officer can respond with contact controls. And so on, all the way up to if the officer perceives assaultive behavior by the subject they're interacting with, then the officer can use up to, depending on the nature of the assault, deadly force. Now that's kind of intuitively acceptable and logical and measured. But I ask you, what if the impressions of the officer are wrong? What if an officer perceives assault when there isn't one? What if the officer perceives resistance when there isn't one? Or if they, in fact, are actively resisting, but that's not happening. For example, what if an officer says, all black kids in a hoodie on a street corner are thugs, and I better watch out? That would lead that officer to respond up the other side. And when that officer is carrying with him or her a load already, an emotional load, a moral injury load, a compound trauma load, that is exacerbated. And you can see that in some of the use of force incidents coming out of the United States. The next topic I want to address is police deception and consent to search. Now, the Fourth Amendment, part of that social contract fabric, provides freedom from unreasonable searches and seizures without a warrant. Now, that's not, again, aspirational. That's a promise. That's a requirement. So because of that, civilians are free to refuse a search or limit its scope or limit its duration. But the problem is that most civilians don't know that they can limit the search or its scope or duration or refuse it. So you go to court and you say, well, geez, I think I should be given an instruction before I'm asked to consent to a search of what my rights are. And the court has said, no, that's not necessary. So we're not going to give a Miranda-like warning before officers ask a civilian for consent to search, whether they understand that they have the right to refuse or not. The problem is, another problem is, 98% of warrantless searches today in the United States are conducted by consent. So in that environment, in that cauldron, the U.S. Supreme Court rather blithely says, it would just be impractical to impose on a normal consent search the detailed requirements of an effective warning. Wait a minute, Your Honors. That's a guarantee, that's a promise, and you're violating it because it's not practical. The reason, yes, certainly the Fourth Amendment sometimes gets in the way of law enforcement. That's by design. That's part of the protection that's built into that social contract. So you watch as that Fourth Amendment, like I said, kind of declines. Again, we're still talking about consent to search. Think about the breathtaking nature of consents to search. When you get a search by warrant in the United States, you have to have it approved in advance by a neutral magistrate. You have to have it approved, but only if there's sufficient probable cause to support what the place to be searched and the things to be seized. And a search warrant has to enumerate the place to be searched and the items, the particular items to be seized. None of those are the case with consent searches. You don't have to have a judge. You don't have to have probable cause or, in fact, any quantum of evidence. And you don't have to say what you're looking for at all. And so in this cauldron of people, civilians who don't understand they have a right to refuse, and officers have tremendous authority to just ask for consent. And if the person says fine, then that's deemed to be voluntary consent, when in fact they weren't informed that they didn't have to give it. Or if they give consent, they could limit it. When you add to that situation race bias or subjective intent on the part of the officers, you've got a problem. And when 98% of the non-warranted searches are by consent, you can see how big of a problem that is today. So it's even worse when deceit is used. They're not just plainly asking for consent to search, but they're not asking at all. They're pretending to be someone else. Maybe the officer is pretending to be a loyal friend, or is a loyal friend, but has turned. Okay, so when that subject says, sure, come on into my house, friend, they're not saying come into my house, officer. They're saying come into my house, friend, because the officers have misled that person into consenting to that entry. That's not consent. Or you have situations where an officer is in disguise, like as a mail delivery person, or pretends to have car trouble, or and so on and so on. And when you add to that technology, and you allow things like false online personas or false Facebook pages or false internet friends and many, many others, with people consenting to searches, they're not consenting at all. They're being deceived into saying sure, but they're saying sure to their friend or a neutral person, or certainly not saying okay to a cop. So is consent still consent if it was gained by officer deception? Well, according to the court, it is. When you look at police deception through in interrogations, you see a similar thing. The Fifth Amendment says no person shall be compelled in any criminal case to be a witness against himself or be deprived of life or liberty without due process of law. And I think Justice Thurgood Marshall, in dissent in 1977, said it well. And in my view, good police work is something far different from catching the criminal at any price. It's equally important that the police, as guardians of the law, fulfill their responsibility to obey its commands scrupulously. Well, that's right, because it's a contract. It's a social contract. It's a guarantee. It's not aspirational, and it's certainly not a technicality. So the social contract and the Constitution both compel that we be fair and just and not compel anyone to speak. But that's not the way courts have seen it. Now, Miranda, again, arising out of the Warren Court long ago, requires a police officer to indicate that the person has a right to remain silent, a right to an attorney, and so on, when they're being questioned while in custody. But let's say there's a situation where the person, the subject, has said, I don't want to talk to the police. And they say, okay, well, we're going to hold you in jail. So they put him in jail, and then they send in an undercover officer to pretend to be a fellow inmate. And then that inmate talks to that undercover officer. That seems to be getting around, not honoring the Fifth Amendment of the Constitution. But that's not what the court said in Oregon versus Mathiasen. They said that's fine, because that's not what Miranda is for. You can mistrust anybody that you wish. I'm sorry. That's not what it said in Illinois versus Perkins. I made a mistake there. If you think about it, that person who is in custody when the undercover officer comes in already said, I don't want to make admissions. So why did they make admissions when the undercover officer went in there? Because they were misled. Not because they consented to give a statement, but because they were misled. They were deceived. They didn't knowingly and voluntarily give up a constitutional right. It was taken from them. Or, misleading a suspect into thinking that that there's nothing to worry about. That's fine. Or telling the subject that his fingerprints or DNA was recovered at the crime scene and matched him. Fine, as long as the guy, confesses thereafter, that's fine, even though it's false. Why did that person confess? Because they were given false information by the police. That's a violation of that social contract. Or manufactured reports showing similar reports that fingerprints and hair matched, or false laboratory reports, or a fake polygraph report. These have all been blessed by various courts as subterfuges or tactics, if you will, to lead, I would say mislead, a person into confessing. And those are all deemed fine, even though the Fifth Amendment argues otherwise. And this goes on and on and on. You can read that if you obtain these slides later. But the point being that officers today are free to mislead. In fact, they're encouraged to mislead by training and also sometimes by administration. And it works. Why wouldn't they use it? It works. But these are not de minimis violations. These are awful violations. Misleading, deceiving, psychologically coercing, or compelling somebody into giving up their constitutional right is a violation of that right, which is part of the social contract, is part of the agreement. So we need to step up and be heard, because we're losing our rights in the United States by leaps and by bounds, not by tiptoe. Sometimes people will argue, well, these aren't my people being deceived, or, my friends and my peers wouldn't be so easily misled, so go ahead and try to mislead them. And if they're suckers, they're suckers. Or these are just desserts. They're bad people, so misleading them is fine. Or if you can't do the time, don't do the crime. Or we have to bend the rules to catch those that break the rules, and so on. You hear this lore of law enforcement and, frankly, prosecution. But that's not the point. The point is the Constitution, the social contract, that is being violated in this era. Just one slide I want to talk about on excessive use of force. I showed you the continuum of force before, but the statistics are clear that 18 civilians are shot to death by police for every one police officer shot to death by a civilian. 18 civilians shot to death by police for every one police officer shot to death by a civilian. And that's not to say, and I'm not arguing, that all those shootings of civilians are wrong. It's suggesting that maybe officers aren't in as much risk of losing their life as they think. And so perhaps we are mishandling use of force, if that's the statistics that come out of it. And that statistic has been consistent at state levels and at national levels for more than a decade. You can compound that by the fact that people of color are killed in those statistics twice as often as their percentage in the population would lead you to expect. And then you can compound that by qualified immunity that protects government officials who engage in discretionary decision-making on the job, as long as they do that in good faith. So these are problems. These are not small problems. These are awful, but have been deemed lawful. Then I want to turn to plea bargaining. In the United States today, 86 to 98% of all federal and state criminal cases are resolved by bargained pleas of guilty. 86% to 98%. And if you think about that, you first think, many do, about efficiency. And geez, we can't give trials to all these people because there's just too many of them. And they're getting what they want out of the deal anyway. And so it seems to be a fair prospect. But I want you to dig deeper into your analysis of that. That prosecutors today, and I was one for 20 years, have sentencing guidelines that give them immense power and immense leverage in plea bargaining. 3 strikes laws that give them immense power. And every legislative session, there's more and more crimes with higher and higher sentence maximum. In many jurisdictions, the prosecutor doesn't even have the obligation to disclose evidence to the defense, or at least not all exculpatory evidence, before they negotiate a plea. They would have to, before a trial, disclose all that evidence, but don't have to before a guilty plea. Think about that. 98%, as much as 98% are resolved by plea bargain, oftentimes with the defendant and the defense counsel having none of the evidence, or not all the exculpatory evidence. Or you have underfunded and overworked public defenders who are trying their best, and many of them are outstanding attorneys, but it's an uphill battle. So this is a problem, not just because of the statistics, but because of what is foregone because of that. In the Constitution and in that social contract, the protections were built in for jury trials. You have a right to a jury trial. You have a right to notice of who's going to be called to testify against you at the trial. You have a right to be notified of the evidence against you to be used at trial, and so on. So all of these first 10 amendments are sketched out in the idea that it's going to be a trial that resolves these criminal cases, because that's what is happening at the time when the Constitution was written. That all of those cases were going by trial, not by negotiated plea, all the serious cases. And so all those protections, according to courts today, don't apply, at least not fully apply, to plea negotiations. So even though 90+% of cases end in negotiated pleas, they don't have the protections that the social contract had in mind, in fact, wrote. And so what can we do? Because it's a toxic stew. You have prosecutors with tremendous leverage. You have defense attorneys and defendants with none of the, or not enough of the evidence. You have sentencing maxima and guidelines that are draconian, are easy to manipulate. And you're negotiating plea after plea after plea from in front of overworked judges who are only too happy to accept that plea deal, and only too happy to accept the factual basis under oath as the truth, when in fact it's often just a mirage. It makes everybody feel better, and it looks stainless steel and all the rest, but it's really just a mirage. So this is so that plea negotiation overload is one of the worst, in my opinion, awful but lawful practices today. Yes, we negotiate a lot of cases, but it's awful because the way we're doing it, at least, is sending people to prison too often for sometimes crimes they didn't commit because they're leveraged into pleading guilty even though they're factually innocent. And also that they don't even have a fair fight because they can't find out what the evidence is against them. We need to do something to stop this awful but lawful era. We need to stand up and step up and speak out, because without it, that social contract, the Constitution, doesn't really mean much anymore. It's more a mirage than substance. We need to deliver a better quantum of justice in the United States. Let's not wait 25 years. Thank you.
Thanks to you for that wonderful, super clear presentation. And yes, without further, please, Dr. Philip Mann, you are in the use of the word for half an hour. Thank you.
Thank you, Mauricio. Can you see my slides?
No yet. No. Did you share the screen? Probably you need to click again on share the screen and select the slides.
How's that?
Now, yeah, now we can see.
Okay, great.
Yeah,
Thank you
yeah.
very much. I thank you for this opportunity to speak today and to be invited to speak. I'm here to talk a little bit about the relationship between police and community, based partly on my experience in the law enforcement arena. In my career, I've always been deeply concerned about that relationship. And I know that Chuck mentioned social contract, and yeah, I like that term. I embrace that term, the social contract with the Constitution. I have a great deal of respect in general for law enforcement. I do. I make no bones about that. But I also believe that we must do everything possible to continue to professionalize policing more and more. And I think there's a role for the community to take a more definite role in that, and it is a balance. So this dialogue is important, and I think to the extent that politicians and community members and others want to be part of this dialogue, they need to ask certain questions, like what is the community's expectations about law enforcement? Do they want police officers to strictly enforce the law? You know, the RoboCop example, there's a violation of law, make an arrest. What laws are the most important laws to enforce? I mean, obviously, there are a lot of ineffective or bad laws out there. Do we want officers to be extremely proactive in an effort to protect the community? How aggressively do we want that to happen? Obviously without sacrificing values in the Constitution. And no matter what stance that is, are these expectations realistic? Or certainly they better be lawfully authorized. And ultimately, it would be, I think, helpful if the community had a greater understanding and perhaps a greater buy-in about the importance of the role of the police and the importance of understanding what they do, how they do it, perhaps changing or professionalizing some of their ways. And yeah, I guess I'll state the obvious here. Police-community relations matter. They matter a lot, and when they are based upon fear, that's obviously an unhealthy development, and it has a cascading effect on the community writ large. When citizens fear and distrust police, or police fear citizens, what's at stake? Safety, security, rights, and our freedoms. All those are at risk. It's not difficult to point to examples of police abuse. I mean, one of the more recent ones that's received a lot of press relates to what's going on I think in Baton Rouge in the Brave Cave. I mean, it's where interrogations are being carried out in a warehouse unbeknownst to a lot of people who should probably know about it. We can go back in history, but more recent history, perhaps we look at Rodney King. We look what happened in 2014 in Ferguson, Missouri. Certainly most Americans are fully aware of what happened with respect to George Floyd and his murder at the hands of police officers. And these are all, I would call them outrageous examples of bad police conduct and often criminal conduct, not simply violations of the Constitution. And of course, there's a racial dimension here. There's a concern about police viewing themselves as that thin blue line, preventing society from sliding into some sort of chaos or anarchy or what have you. And it's also unhealthy when it rightfully, it's unhealthy if the community rightfully believes that the police are their oppressors, their occupying force. And this all leads to this swirl of a less safe and less secure communities. And in that state, it's very difficult to have meaningful dialogue and meaningful exchange of ideas, because if we're going to effect change, certainly we heard that in the previous presentation, there needs to be some sort of dialogue, constructive dialogue and understanding. So how are we going to affect change? Are we going to affect it by reform, from above, as in legislating change, or are we going to support or better develop change from within police departments? Now, obviously, there are a lot of critics who say police are not going to change unless it's forced upon them, and I realize that's a legitimate argument. Or is perhaps there a combination? Are there some police departments, and there are some police departments that are taking the lead in trying to professionalize and improve what they do? I mean, there's conversations about defunding the police or otherwise reducing the funding and footprint of police in society. Some would simply pass more laws, directives, or policies, or enact policies, or impose policies that would more fully regulate police activities, certainly beyond the constitutional standards laid out by the Supreme Court. I think there's a lot of opportunity to address some of these concerns through better police training, the development of a stronger or better culture, and the relationship and role of the police with community. Is there a need for more oversight in many cases? Oh, absolutely. Do there need to be more checks and balances? No, we don't want anybody holding a lot of power to be unaccountable to the people. That's not part of the social contract. But I think we need to have healthier conversations, meaningful conversations, not black and white, but we have to try to search for some common ground in seeking justice and understanding in this relationship between police, citizens, and community. My interest in this is born out of my work in the Bureau, and I know I was not a police officer, but I made a lot of arrests, conducted a lot of searches, worked a lot with other police officers and lots of different agencies. And yeah, I do have a very deep interest in promoting principles and values that strengthen that relationship between police and community. And I'm especially interested in the dynamics of power and authority that permeates police-citizen interactions. Let's face it, police have power and authority, and I hope it's authorized power when it's exercised, that's unlike anything that any citizen possesses. And of course, there is the potential for abuse. So these are just some of the points I'm going to address separately. I think we need to better define in this conversation, in this dialogue, the role and limits of police and recognize that their work, it's different. It's clearly different. And yeah, it's difficult. I make no mistake that, and there's also a lot of pressure. There's a lot of danger inherent in the work of police. I don't think society, I don't think we can minimize that. That is part of the job, but that doesn't allow for abuse of power and other issues. And certainly it requires abides by to the Constitution. We have to also look at the legacy of policing, the role of power, which I've already mentioned, the issue of discretion. Police in their position have a lot of discretion. And there are those who would like to hamstring that discretion more. And there are those who say, leave it alone. Police need the breadth of discretion to do their jobs effectively. And I'm not leaning one way or the other, but I think that needs to be part of the conversation. And I think it's helpful to the extent that we can identify shared values between police and community. What are some universal or more shared values? And if to the extent that those values exist, how does that inform police training and police actions, and certainly their any interaction with the community? And certainly I promote the idea of a culture of law and integrity among police. I mean, I want it to be a calling, a vocation. Obviously we need to be careful about the people we hire, given the immense power and authority that they possess, and there needs to be checks and balances and like things. So police work is different, and it is different. There are no civilian jobs out there that really resemble what police do. And yes, their training, their work, their methods, their tactics are not fully understood by the public. That's part of the conversation too. Can the work of police be entirely transparent? How they make a case, how they develop, certain practices and procedures, or develop undercover operations. Can everything be transparent? No, I would strongly oppose that. But can there be more transparency? And yeah, I would argue absolutely. And to the extent that the public has perhaps a better sense of what police do and why they do it, that could arguably strengthen trust and confidence in the work of police, because it is important work. Promoting safety and security, protecting and serving, they're important. People should care about that, but not not to the extent that they should be sacrificing other values or their constitutional rights. Yes, police have the authority to use force, and I teach for the use of force up to and including deadly force. At least I did, was with the Bureau. And yeah, force, the ability to use force is power, unmistakably. And when I say that, I also am mindful of the importance of hiring people who don't see becoming a law enforcement officer as an avenue to exercise power. That's a scary thing. There was one time I was asked to serve as a recommendation for somebody, and I declined to do that. And I ultimately was interviewed by a police department because I was concerned that this young man really wanted to become a police department so he could carry a badge and a gun and no more. And there was no sense of public service or a respect for the, real deep, abiding respect for the value of laws and the Constitution, and some of the very points that Chuck has raised. So yes, power can be rightly used, and of course it can be wrongly used. A proper arrest is an important thing to take somebody off the streets who could be, who is a threat to society. But that force has to be used properly within the law. And yes, the use of force has broad impact upon how society views the police, and all we need to do is witness the number of examples. I'm in an earlier slide, or we just simply watch the news when a police officer oversteps his or her bounds and either abuses the power or even sometimes commits crime. But also, I also want to say police work is, re-emphasize that it is different. You think about a protest and the difficulty of police work, and I like to point this out to students sometimes. Often in a protest, there are protesters and there are counter-protesters, and it can easily slide into violence. Now, arguably, in one sense, police officers are upholding the exercise of First Amendment rights, but at the same time, they have to afford security so that each side can safely express those rights. And at the same time, they also have to ferret out crime. So it's a very complex relationship there, and that is hard work to do it well, to still uphold the values, constitutional values. And I think police academies I don't presume to know what every police academy teaches, but I think it's really important that police academies look at history, look at whether it's within the United States or whether there are examples abroad, and it's easy to point, for example, to the compromise by the Nazis of civilian police departments, and there are countless other examples too. But we do not want, I assure you, and I suspect most of the members of the audience would wholly agree, we don't want a police who are beholden to those who are in power, political power, where they simply become instruments of the government rather than individuals who protect and serve and uphold the rights of citizens. And yes, they need to be accountable. They need to be accountable to people. They need to be accountable to principles. Another example that many of you are probably aware of in the United States, certainly, are the use of slave patrols dating back into the 18th century, 17th and 18th, and to some of the 19th century. I mean, that's just obviously, that's a horrible abuse of power. It's also unconstitutional. It's criminal. It's so many things. That legacy exists, and I don't think we should shy away from that. That doesn't mean we demean what police do. It's just a reminder to police there is a legacy here. So yeah, don't ignore history. We can look at the police being involved with strike breakers, as enforcing unjust laws, unlawful laws such as Jim Crow laws, and yes, there were slave patrols. It's important to be transparent, because I think transparency and honesty is so important to developing credibility and trust with the public. So yes, use history as a lesson. The issue of power is, I've always had an interest in that power dynamic, and it was reinforced to me when I was reading something written by a former Baltimore police officer. I think he was the last before he resigned, he was a detective. And so I'm quoting him here. Making the transition from civilian to cop was overwhelming. I wasn't accustomed to exerting any type of authority. And now, after 6 short months, I was given the power to take away somebody's freedom and the instruments to take somebody's life. At the police academy, we were taught the basics of the job: driving, firearms training, report writing, and self-defense. Now, those are all important. I grant you that. But the academy did not teach us the fundamental difference between power and authority, or how to judiciously apply either. You know, you just don't carry the badge and the gun and walk around and exercise power. You have something that's been entrusted to you, perhaps as part of the social contract, and you need to use it wisely. And that is just a concept that I think needs to be so underscored in the training of all law enforcement officers. I always would say to other officers and formerly fellow agents, anytime you exercise your power and authority, there better be a legitimate law enforcement objective behind it, whether it's using force or some other dynamic. And the use of power and force should never be gratuitous. It has to be founded and guided by laws and policies, and yes, values and ethics. There's a difference between arresting somebody, lawfully arresting somebody who's perhaps accused of murder, but then and perhaps even inwardly hating that person, despising that person. But after those handcuffs are put on and that person is secure, it is not the role of a police officer to punish that person. That is not the police officer's job, or the law enforcement officer's job. That's gratuitous use of force, and that is unacceptable. Another aspect of policing, and that is, and I mentioned it earlier, the role of discretion. We could have I think some very legitimate conversations about just how much discretion can a police officer, or should a police officer, have? Because discretion in and of itself in the work of policing is a form of power and authority. If officers are afforded choices, whether to enforce the law, whether to let something go, whether to arrest somebody, perhaps how to arrest somebody, presuming the force is used reasonably. All these things are elements of power. The decision simply to pull somebody over. Too much discretion perhaps promotes abuse. But on the other hand, can you not literally, but figuratively handcuff police? And if you do that, does policing in essence become ineffective? Another point that I don't think can be overemphasized in the law enforcement academies, and frankly, it should be shared among all of us, and that is the importance of the rule of law. It's something it should be at the forefront. No one is above the law, and there are many different ways of thinking about and just explaining the rule of law, but the law must guide everybody who's subject to it, and that's all of us. And that, of course, includes police. And if police are not obeying the law, following the dictates of the Constitution in court cases and the like, it certainly undermines public confidence, as it should. Because the rule of law, and I like this quote, it allows us to live in a civil society in which everyone's rights are respected, where each of us is guaranteed liberty and equality of opportunity. So when police violate that, if you want to call it sacred trust, they do more harm than they do good. And yes, police are supposed to be role models. It's a tough job. It's a job that I would want to be respected, and whenever possible, it should be, because it is such an important job. But police must also always be mindful of the importance of the rule of law. And yes, values and principles, not just the Constitution, which certainly embodies various values and principles, but values and principles should be a very significant part of developing the right police culture. And yes, I like the word integrity. Promote a culture of integrity in all police words and actions. They have to be self-disciplined. They have to be professional. And no, when they're not, that's a problem. It's a huge problem, and it can lead to terrible decision making. What are some of these perhaps universal or constitutional values that should be embodied in the work of police? Equality, liberty, due process, and the dignity of every person. I'm not the first one to mention any of these aspects, but I think they need to be reinforced. both in the selection of police candidates at police academies or law enforcement academies, and certainly throughout the practice of policing. And yes, character matters. I think we need to say what types of character really matter in policing. Honesty, obvious. I mean, this sounds like a Boy Scout, but yes, honesty, or Girl Scout. Humility. I think humility is a huge, extremely important character trait to bring to policing, because those who have that power and authority but lack humility are liable to do some damage. And of course, policing does take courage. And I think we should be looking for people who are committed to public service. It is a public service. So these characters, these principles need to infect every aspect of the selection of identifying people to become police officers, of selecting them, of training them, and simply in the business of policing. Among some of the principles that I really respect and appreciate in my research and reading in this arena, and include Professor Dr. Tom Tyler's 4 pillars of procedural justice. Some of you might be quite familiar with it, I suspect. Where the 4 pillars are fairness, voice, transparency, and impartiality. I don't think I need to go at length in that, but what matters is how are these pillars practiced in the actual work of policing, to the extent that a search is conducted, an arrest is made, somebody's arrested perhaps, or somebody's pulled over. Think about transparency. It's certainly, even if it's not always required that a police explain his or her actions in complete detail, to the extent that a citizen asks a reasonable question, a police officer should answer it. And yes, of course, we should be treating people with neutrality and impartiality. I mean, that's a commitment that must be taken seriously by all law enforcement officers and any of those who are overseeing their work. We could have lots of conversations too about the role of citizen oversight boards. I mean, that's an arena that's continues to develop. And we could entertain lots of questions about the extent to which citizen oversight boards or civilian oversight boards would have in the workings of police. But there are just so many conversations that I think have to be more openly had at this point, rather than people moving from in one corner and perhaps demonizing all police work, and those who would simply say, well, everything police officers do is great. We always support the police. No, we support police who are practicing with integrity, with honesty, consistent with the Constitution and ethics. So in any event, I think I'm nearly out of time, and I'm gonna turn this over now back to Mauricio, if you would, and if anybody has any questions.
Yes, thank you so much for your presentation. And as you said, please, all the attendees, this is the perfect moment for your comments and questions. For now, I don't know if you want to read it yourself. We have a question from Atina Stafila in the Q&A button, or if you prefer, I could read it to you. And please feel free to both of you to answer or acknowledge the comment, okay? So, yeah, it says, to the second topic, the discretion of policing should be controlled and limited. I agree to that point with the speaker. And here comes the question, yeah. Does the proportionality principle, as we know it in Europe, help in this problem? Should the police officer use its discretion in forms of action harming protected human rights of the suspect in accordance with the gravity of the action? And she adds finally, it is awful to hear that a police officer used electroshock to an adolescent driver because he had not a driver's license to show him.
Yeah. I hope I didn't mute. Can you still hear me?
Yes, we can.
Okay.
Yeah.
as far as proportionality, in terms, I'm looking at this from the prism of proportionality of force. To me, the concept of proportionality is very consistent, at least to me, to the idea of reasonableness of force in interpreting the Fourth Amendment of the Constitution. When we search and seize, everything's supposed to be reasonable. And yeah, I think proportionality is an important concept. I don't presume to know exactly how it's understood and explained in Europe, but it certainly appeals to common sense and rational thinking. Whatever force officers use should be commensurate to the threat that's real or objectively perceived, and that can be, in the choice of force, and not only just the choice of force, but how that force is carried out. And I hope I partly answered that question. And then I heard the second part about the use of electric shock, if I'm not mistaken. But when I think of electric shock, tasers, for example, I'm always concerned about the use of some of these devices that are arguably less than lethal devices. Yes, proportionality in the use is an important concept in applying something like using a less than lethal force, such as a taser or some other device, or chemical weapons. I don't like using the word weapons, but chemical devices, they are weapons though. They have to be used judiciously. Most of these should not be, as Chuck well knows, they should not be a first option. They should be used when the moment is appropriate, and based upon experience, based upon rational thinking, experience, common sense. Because if the use of force is seen as gratuitous or as unnecessary, it looks more and more like punishment rather than the enforcement of law or something that serves a legitimate law enforcement purpose.
Yeah, if I could weigh in on that one. Use of force in the United States is about, in virtually every jurisdiction, reasonableness and necessity. Reasonableness, as Philip noted, is about proportionality, indeed. But necessity is often forgotten. And to me, the necessity thought is, at least if you look at the dictionary, there is no other option. It's necessary, right? You have to do it. This is the only thing. My problem with use of force today, one of my main problems with it, is that we just look in the instant of the response. So in that instance, he was really close. The officer was really close to a person with mental health challenges who was holding a screwdriver. And so he took the action that he felt was reasonable and necessary at the time. And in that microcosmic second of that decision, I agree with it. That's right. If it's close enough, that's right. My argument is that trained professional law enforcement officers should do a far better job before that instance, before that instant. What do you do in terms of tactics? Do you put yourself between a parked car and the person with a screwdriver? Do you leave yourself no avenue of exit? That, in essence, it could even be argued that the officer created the emergency and then it was deemed free to respond to it. I'm troubled by that. I think it leads to too many lazy tactical decisions being made, and it leads to too many tragedies. I mean, as a prosecutor, I was often called to be the conflict prosecutor for officer-involved shooting deaths. And as long as it was reasonable and necessary, I didn't even take to a grand jury. But I was always shocked when I decided that it wasn't reasonable or necessary, and I went to a grand jury and they no-billed, they failed to indict. And the reason for that is partly we rely on law enforcement to be the wall, right? To take the risk, to take the threat that we're not able or willing to take. And so they're going to bend over backwards. But I believe that the statutes mean something, and that, as Philip noted, when you add ethics and morality on top of that, it means even more. So I would like to see a change to use of force practice to include not just the instant, not just the moment, but also the tactical decision making.
if I could just partly respond to that too, to what Chuck said, and what we're flying in the face of here is that the Supreme Court's points about we don't view the use of force or deadly force 2020 hindsight. And so that is a problem right now. If we're and I don't know if Chuck, you wanted to weigh in on that.
I would, yeah. That goes back to my discussion earlier about the U.S. Supreme Court. You know, they're capable of being wrong. And we need to confront that. We need to do something about it. To me, for example, in the Wren case, where the Supreme Court said, you know, an officer's subjective intent is irrelevant as long as what they did was supportable under the Constitution. Well, that's absurd. I mean, if an officer hangs out outside of a Hispanic trailer park to try to get the next person with a bad license plate like because they want to hassle Hispanic people, that's awful. But according to Wren, the Wren case and the U.S. Supreme Court, that's just fine. And my concern is that we need to, some would say, I mean, I'm a product of the 60s and 70s, question authority, right? I would argue that that's what we should do is question authority of that. Yeah, that's what the U.S. Supreme Court said. And they've in fact said we're not going to rely on hindsight, but we're also not going to look at what led up to it. And we're not going to honor the concept that if officers created the emergency, it's not an emergency. So they've already said all those things. But that's not the end of the analysis for me. The U.S. Supreme Court is not precedentially bound by its prior decisions, and it can change its mind. And there can certainly be a change of personnel in the court that can change it. So I think we ought to keep speaking up. But you're quite right, Philip, that for now, that's the practice. That's the rule. I wanted to comment too, if there's not another question.
We have another question, so maybe I can read it to you and then you can answer together with your comment, if that's okay. Yeah.
Sure.
It says, related to the first topic, how and with what kind of measures and legislative projects will we bring the lawful but awful era to an end?
I would speak in generalities. I would say be persistent and creative and patient. What we do in my school is we do exactly what Philip recommended, that it really is in large part about recruitment and selection. So we spend a lot of time focusing on the core of our students, making sure that those who we bless with our degree and prepare them to take the licensing exam, that they're ready, that they're not going to be a risk to somebody's kid in the middle of the night because they've got an emotional load on, or they've got an axe to grind, or their uncle used to do it this way when he was a cop, or whatever it is. And so that's one thing, but that requires patience, because what you're doing is those young people that you select that are talented and driven to be part of the vanguard of change will ultimately get a job and will move up in the ranks and ultimately replace those who are there now who aren't as good at being just and fair and really were from a different era. So that requires diligence and patience. In terms of creativity, I think we need to require changes, for example, to the use of force approach, that we require better tactical training and decision making, that we broaden the scope. So, for example, not just with law enforcement, but if you look at laws like stand your ground. I mean, stand your ground had a fine principle originally that you could stand your ground and act with deadly force if you were standing your ground, basically, whether you were in your home or not. And that was driven by the public, right? The public wanted a certain fix to this. The problem with that is that increased suicides by gun, it increased homicide by gun, it increased accident by gun, and didn't do much to improve home safety or home security or individual security and safety. So we need to be creative, not just knee-jerk. And what factors into that, in my opinion, is act utilitarianism, many officers rely on the concept that I'm here for the greater good. What serves the greater good? And if the greater good is what the majority wants to have the police do, well, that works out great for the majority. Doesn't work out so great for the minority. So act utilitarianism and greater good thinking by law enforcement always, or often, too often, leads to diminishment of minority rights. So what can we do in terms of legislation and moving the needle? I think we need to disabuse legislators and agency directors and sheriffs and chiefs and so on of this whole greater good mentality. You're not to serve the greater good. You're to serve every single person with equivalent justice, every shift. And once that change happens, then doing the right thing becomes automatic, autonomic. They don't hardly have to think about it. The thought goes to their spine and back out. It doesn't, they don't have to cogitate about it. So that's my 2 bits. It's not particularly specific, but it's generic.
I would just like to add one point for consideration too. It's certainly in the United States is, yes, we have a very broadly interpreted Second Amendment. We also have the widespread possession of weapons of all sorts. And to the extent that police are well aware that many, many people have weapons, doesn't that also color the decision-making process among police officers?
Absolutely, it does. And particularly if officers believe that their prime directive is to return home to their family at the end of the day, which a lot of officers do wear that every day, then yeah, you're always assuming that everybody's armed. But that, remember, back to the continuum of force, that leads you farther up the left side, which leads you farther up the right side, which causes problems. And so my sense of it is, first of all, the Second Amendment is improperly construed at present. If you look back to other courts and other justices of the Supreme Court, they've said that's the biggest fraud that's ever been pulled on the American people, is to say that the Second Amendment is not based on arming a militia. It is, by its own terms, it's for arming a militia, not so everybody can have an Uzi in their basement or 50 Uzis in their basement with 100 round magazines. So that's one thing. A second thing is to remember the statistic I gave that 18 civilians are shot to death by a police officer for every 1 police officer shot to death by a civilian. So I think at least one thing you can draw from that is that the thought process is wrong. The fear for life at any moment to be snuffed out is wrong. It's a dangerous job, and so your life and health are on the line every day. But that should not predispose you 18-1 to shoot when you're perceiving too high up on the left side of that. Continue.
Wow. Okay. Thank you so much to both of you, Dr. McLean, Dr. Mann. This was Perspectives on Law Enforcement and Community Relations. Thank you for joining. We are closing now the panel, but if you want to remain in this room, in about 10 minutes, we will begin with crime in Latin America, current issues. And if you decide to join other panels, continue enjoying this International Criminology Conference. Thank you so much. Yeah, and see you.
Thank you. What an honor to appear with you, Philip. Thank you.
Likewise. Likewise. It's a pleasure. Thank you.